Lordship, I would like to mention item number 27 on behalf of Estapin, Your Lordship.
27.
Yes, Your Lordship may kindly take up this matter tomorrow, Your Lordship. I've taken the consent.
Tomorrow.
Yes, Your Lordship. 27.
My lord, yeah, I have no objections. I am for the petitioner.
On the prayer of on the prayer made on behalf of Mr. S. Tapit, Learned Senior Government Advocate. Let's this matter on 28/03/2024.
Tomorrow. My lord, item number 31, I will be appearing for respondent number 4. I am yet to file my wakalat number, but my appearance may be recorded also today. Give me some time. 31, 4 weeks time.
Mr.
Your
T.
Honor,
Patil, Learned Counsel submits that he would be appearing for
respondent number 4.
lesson number 4, for which he seeks 3 weeks. 3 weeks time.
4 weeks.
4 weeks time to file.
Your Honor, it was for consideration of interim.
Today.
Yes, Your Honor. So it can be listed on Your Honor if possible, you know, on 3rd of April. On 3rd of April. Yes.
3rd of April.
Yes, Your Honor.
We'll see.
My lord, otherwise then on the 10th of April.
Then it's working day.
10th of April is a working day.
Then in that case, 9th, 10th.
10th.
Then 10. 6, 4.
My lord,
Sometime for sometime to file counter affidavit. Then you just write on the consent of the parties, list this matter on 10/04/2024.
my lord, is another contempt. The business will be listed tomorrow, my lord, for orders.
This is
Contempt matter.
contempt. So why tomorrow? 1st of April. Anyway,
We'll see, my lord.
Your Lordship, I beg to mention item number 19.
19.
As main counsel is out of session. Your Lordship, in this matter, interim is there, so it may be continued. And matter may be fixed after this one.
What did you say?
There is a interim in this matter.
What is to be done?
1st April.
Yeah. On the prayer of MS so Learned Counsel for the petition applicant, list this matter after 1 week.
Your Lordship, again, item number 29 and 30. On behalf of respondent, petitioner.
21 and
29 and 30.
29 and 30. Yes,
Matter may be fixed after 1 week.
yes.
My Lordship, there is an interim order, Lordship.
Okay. 29 and 30.
Lordship.
On the prayer of Learned Counsel for the parties, list this matter after a week. Interim order post earlier shall continue.
My Lordship, I like to mention item number 25
25.
on behalf of the Tabaks. On behalf of the Tabaks.
Mr. So-and-so, Learned Counsel appearing on behalf of Mr. T. Tapak, Learned Counsel for the petitioner. List this matter after
3 weeks.
3 weeks. Yes, yes.
Your Lordship, I beg to mention item number 15. Lordship, conducting counsel A. Tatak, Adam Tatak is on leave.
On the prayer made on behalf of Mr. A. Tatak, Learned Counsel, list this matter after 4 weeks. 4 weeks.
Must oblige.
My Lord, item number 21 and 22.
Yes.
Council is out of session. Kindly, my Lord, fix date may be given. Fix date may be given for 1st of April.
This has been fixed and you are the messenger, will not fix it. On the prayer of Learned Counsel for the petition.
There is interim also,
list
my Lord.
this
It may be
matter
continued.
After a week.
Okay. Interim was also there.
First earlier shall continue.
Okay, much obliged.
Lordship, I beg to mention item number 12 and 13.
12 and 13.
I'm appearing on behalf of L. Perme. standing counsel for power department.
12 and 13. This 12 I cannot take up. You like list this matter before any other appropriate bench without me. 12. And item 13 on the prayer of Mr. So-and-so, learned counsel, appearing on behalf of Mr. L. Permet. Standing counsel, horticulture.
Power department.
Item 13.
12 and 13.
12 is something different.
Yes,
12
13.
I've already passed out. I
Yes.
cannot take it.
Item number 13
13 is
for power
learned standing counsel.
power department.
No, this horticulture and horticulture something like that.
13. Oh, agriculture.
Learned standing counsel. Same on behalf of Mr. L. Perme, learned standing counsel, agriculture.
Yes.
Phrase for listing the matter after 2
Right.
weeks. List after 2 weeks.
May it please, Your
Phrase,
Lordship.
list after.
May it please, Your Lordship. Lordship, in item number 1, I have filed my wakalatnama this morning, Your Lordship.
Item number
1.
1.
The same may be brought into record, Your Lordship.
It's okay.
Uh,
Power only.
Yes, only power.
Item number 1.
1, Your Lordship.
CRP.
CRP.
Okay.
My lordship. Lordship, in item number 23. In item number 23, we need some more times to file rejoinder affidavit.
You are for
Petitioner.
on the prayer of Mr. So-and-so learned counsel for the petitioner.
Yes, sir.
Is this matter after 2 weeks so as to enable him to file? So
Kindly 4
enable
weeks.
the learned counsel with petitioner
Lordship,
to
kindly
file,
4 weeks.
rejoinder 4 weeks. In that case.
And Lordship, meanwhile, there was an interim order. Kindly
Interim
may
order
continue.
was they shall continue.
Review of it.
My lordship, lordship, I beg to mention one unlisted matter,
What unlisted?
criminal petition,
What is the urgency?
urgency.
There's no urgency next week.
I was directed by my senior. I was directed by my senior.
Who?
This matter may be Pitam Tapo, Mr. P. Tapo. He's out of station right now. He's out of station right now, so I was directed by him
So
to list this matter today. So
list this.
yeah, ma'am.
List the matter today.
Today, yes. So this matter may be taken up today. Your Lord.
No, today it's not possible. Either tomorrow or next week. Tomorrow.
Much obliged.
May I please, madam?
Yes,
I beg to mention item number 24.
24.
Yes, I'm for the Malad Elena Parme. She is for the petitioner. I'm for the Malad Elena Parme. She is for the petitioner, madam. She is
On
Malad
the
out
prayer of so-and-so. When do you want?
after 3
Learned
weeks.
counsel for the petitioner. Learned counsel appearing on behalf of MSE permit. Learned counsel for the petitioner. List this matter after
3 weeks, madam.
3 weeks.
Obliged.
Your Lordship, I beg to mention item number 18, 13, 14, and 15.
One by one, please.
8,
18.
8, sir.
8.
8,
8.
13,
7, 8, and 9.
Yes, lordship. Yes, 7, 8, and 9 is connected, my lordship.
Is there any live issue? 8, 7, 8, 9.
Right.
You are appearing for
on behalf of Deep Panging.
petitioner.
Yes, my Lordship. Council is out of session.
You are appearing for item 8 and 9, Deepanging. And
I'm
you are for
7, lordship.
7, item the petitioner.
Lordship.
And 7, 8, 9. On the joint prayer of learned counsel to the petitioner. This matter after 6 weeks.
Lordship, 3 weeks.
3 weeks.
Lordship, item 13
13 is
Well,
what? 13 already adjourned.
and my Lordship, item number 14 also.
14.
And there is an interim order which
On the prayer of so-and-so learned counsel. List this matter after 4 weeks. Interim order passed earlier, shall continue. Item 14. Then
also, Your Lordship, item number 32.
32 is 2016 matter. We'll see. 2016 matter. Have you read the file? Just now, read it.
Obliged.
We'll give you 1 hour.
May I please, Your Lordship?
Yes,
I would like to mention item number 33
33.
to be adjourned for today.
2018 matter.
Yes, but
Also,
the
no,
but the
it
learned counsel is out of station.
doesn't matter. Do you have the file?
No, I don't have the
You
file.
get it? You see get the second file, we'll see. No adjournment.
My lord, I am filing 3 bail application.
Tomorrow.
For today, kindly, my prayer is that kindly take as unlisted.
So my request is that it should be listed tomorrow.
Tomorrow.
Urgency is there.
Yes, my lord.
What is the urgency?
Uh,
Are you absconding?
no, my lord, I am actually in jail.
There is
And
no-
I have to conduct an examination. I am a principal of the school.
Ah,
The
what
already
is the offense?
offense, there is still no charge sheet regarding me. But
So
the-
there is no offense.
only the
We'll see tomorrow. Tomorrow.
May I, my lordship?
Yes.
I beg to mention item number 11, my lordship.
11.
This matter may be listed next week, my lord.
11. On the prayer of MS Wangmo. K. Wangmo, London State Council, list this matter after a week.
May I, Lordship?
Yes.
Lordship, I would like to mention item number 34.
34.
Yes, Lordship, here, Mr. Elbam has been appointed as a new counsel for the appellant,
Elbam.
Elbam. Yet
Where
to-
is?
He's not here today, out of station. Your Honor. The matter may be taken up after 4 weeks, Your Honor.
Accused is in jail. Accused is in jail.
Your Honor,
Jail.
I have no idea, Your Honor. As we have not yet received the record, yet to file our wakalat nama, Your Honor.
Anyway, I think we cannot take it up this matter. List this matter before any other appropriate bench without me. 34.
Obliged.
I may please, Your Honor.
Yes,
I'd like
yes.
to mention item number 26.
26.
On behalf of Ms. D. Tamo, she's currently out of station, Your Honor, as this matter may be fixed after a week.
On the prayer of MS
T.Y. Bhutia.
T.Y. Bhutia, Learned Counsel, appearing on behalf of
D. Tamo.
D. Tamu, MS D. Tamu, Learned Counsel, London Amicus Security. List this matter after
1 week.
1 week.
Deeply obliged.
May I, Lordship?
Yes,
Your Lordship, I have to mention item number 28.
28.
Yes, Lordship.
On the prayer of so-and-so, Learned Counsel.
Your Lordship, I humbly apologize for the inconvenience.
Hmm.
Matter may fix for tomorrow. I forgot to bring my file, Lordship.
Which one? Item 28.
Yes, yeah, madam.
Then next week.
Lordship, please, tomorrow.
Next week.
Okay.
In any case, we'll see. It's in order stage. We'll see what is to be done. Item 28. You be there. We'll see.
Okay. Lordship.
It's in the order column. We'll see, huh?
Okay.
We will wait for some time. Item 28.
Yes.
Item number 1.
My lord,
Where's the caveat?
this caveat, my learned friend is a
Caveat.
No, Your Lordship, caveator, Mr. P. Tapo is
Huh?
P. Tapo.
Where is?
He is out of station, Your Lordship.
So,
Your Lordship may pass, take up this matter on another date, Your Lordship.
Lord,
Any other date, Your Lordship. He just informed me that he left the court premises by evening yesterday, Your Lordship. Today is the
is
file.
it related to the election?
my lord, the case has got its own urgency. My lord, your lordship will see that how the injunction was granted. My lord, your lordship will find that both the court below went on reverse angle, my lord.
No, if it is not related to, since he is seeking an thing.
My lord, that will create some problem because today is the last date for filing nomination and tomorrow is the scrutiny. So therefore, it has direct relevance of that part is
But
concerned.
in any case,
My lord, I'll try to convince your lordships, my lord, what had happened in this case. My lord, as your lordship is aware, in civil case, the plaintiff has to stand on his own legs. Now here what happened, both the courts, my lord, scrutinized the case of the defendant and they did not go to the case of the plaintiff. This is the reverse gear they have gone.
you are not ready.
Your lordship, otherwise I'm,
If you are not ready, why you have to file the power?
yes, your
Well,
lordship.
here,
yes,
we'll see.
Yes.
We'll see.
My lord, I'll try to
Yes.
convince your lordships. My lord.
Yes.
Now, the short fact is, the respondent as plaintiff,
Yes.
by filing title suit, obtain interim injunction, that is on 22/12/2023, whereby election result dated
22,
22/12/2023.
23.
My lord, that order your lordship will find at page 166.
Yes.
Ex parte injunction order. Now, by virtue of that order,
166.
166, my lord. This is the order dated 22/12/2023.
Yes.
Today is fixed for necessary order. The petitioners are represented. Your lordship may skip that. The case of the petitioner's plaintiff is that the plaintiff number one is the president of People's Party of Arunachal and plaintiff number two is the secretary general as per election held and result declared dated 14/10/2022. The defendant number two was the chairman of Central Working Committee. However, on 24/9/2022, the executive members of PPA convened a meeting and resolution was passed to remove the post of chairman by Fourth Amendment on 4/11/2022. Thereafter, the defendant number two seeks to be the chairman of Central Working Committee. That while letter dated 14/10/2022, the president of PPA submitted the updated list of office bearers to the Election Commission of India. However, the Election Commission of India, by letter dated 18/9/2023, informed that the details submitted are not in prescribed format of the commission. Therefore, on 27/9/2023, the plaintiff submitted the details as per the prescribed format to the Election Commission of India. The defendant number two issued circular dated 4/11/2023 to convene a meeting by stating that the present office bearer's tenure has expired on 22/12/2021 as per the Election Commission notification dated so and so and published the same in local daily newspaper on 11/11/2023. On 11/11/2023, the plaintiff issued a press notice informing party members to refrain from taking part in the meeting as it is unauthorized and illegal. The meeting was held anyway and defendant number one, Sri so-and-so was appointed as returning officer and conducted election on 12/11/2023. And result was declared on the same day. The defendant number two was elected as chairman CWC. Defendant number 3 to 22 were elected as state executives. London Counsel, Mr. So-and-so appearing for the petitioner's plaintiff submitted that as per Article 16 of the Constitution of PPA as amended on so-and-so provides for PPA Central Working Committee. As per 16(1), the president of the party shall be the chairman of the PPA CWC. Therefore, there is no separate post of chairman CWC. The defendant number two illegally issued circular dated 4/11/2023 and defendant number one illegally conducted election and declared result dated 12/11/2023. Therefore, the election result dated 12/11/2023 is illegal and liable to be quashed. And in the interim, the defendant be restrained from terming themselves as the People's Party of Arunachal Pradesh. It is prayed that temporary injunction may be granted ex parte or interim as the object of granting the injunction would be defeated by the delay in service the notice of application to the opposite parties. Peruse the plaint, miscellaneous application and the copies of documents. Upon perusal of records and hearing, it is seen that The present case has been filed seeking for decree in favor of the plaintiff for declaration of title in their favor and a decree declaring the election result dated 12/11/2023 as illegal and permanent injunction under section 38 of the Specific Relief Act by prohibiting the defendant from terming themselves as the People's Party of Arunachal Pradesh. I have also gone through the letter dated so and so by the Undersecretary Election Commission of India to the President of PPA, wherein it is stated that in regards with the updated list of office bearers furnished by your letter dated so and so, it is informed that the details submitted are not in prescribed format. Therefore, it is advised to furnish the organizational election details of the party, along with a complete list of office bearers, members of the committees, etc., elected at such elections in the enclosed format. In the said letter, the Election Commission has not stated that the tenure of the present office bearers expired on so and so. I have also gone through the constitution of the PPA as per article so and so of the president shall be elected for a period of 3 years, which implies that the tenure of plaintiff number 1 will be till 14/10/2025 as the election result was declared on 14/10/2022. The election result has not been challenged. Further, Article 14 of the Constitution of PPA as amended on so and so provides for PPA Central Working Committee. As per 16(1) of the President of the party shall be the chairman of the PPA CWC, which implies that plaintiff number 1 is the chairman of CWC. Further, as per Article 38(1)(a), the President in consultation with the state executive shall appoint a returning officer for conducting election of the party, which
Yes, it's
further
okay.
implies.
It's okay.
Now, your lordship can see the
Come to
finding.
that finding.
Finding
The
your
order.
lordship will find at page 169.
According the election result.
Accordingly, the election result of the defendants number 2222 dated 12/11/2023 declared by defendant number 1 Sri so and so is hereby stayed until further orders. Further, the defendant number so and so are restrained from functioning as state executives, PPA, and further directed to refrain from using the emblem stamp. Now, your lordship kindly see the plaint has been, my lord, the case has been, suit has been filed. My lord, I will take your lordships to the plaint now. Your lordship will find it as page 74.
No, this, against this you have filed an appeal. You have
Yes,
approved
yes,
the,
appeal has been filed and your lordship will find the appellate order, your lordship will find at page 57, no? The impugn order at page 44.
44.
Yes. The appellate court
The
also.
appeal has been rejected.
Appellate court also committed the same mistake. My lord, your lordship may see the finding is a copy paste finding. I'll have to say that only because the appellate authority also did not apply their mind at all. Lordship may come to page 54, paragraph 18. The crux of the issue has been, my lord, given a go by totally. Page 54, paragraph 18. As your lordship got that.
Yes.
From the aforesaid highlighted portion of the impugn order, it is seen that the learned court below has duly considered all contentions of both the parties in the application under Order 39 Rule 1 CPC in the miscellaneous case so and so and has referred to relevant articles of the Constitution of PPA and thereafter come to the decision that although Fourth Amendment to Constitution of PPA made by respondent number 1, 2 and other members of PPA executive body has not complied with the provision of Article 29 of the Constitution of PPA, which requires people assembly to be held and 1 month prior notice, but same cannot nullify the election held on so and so, which was conducted by duly appointing a returning officer and by complying with the due procedures for conducting an election as required under Article 38 of the PPA Constitution. It is seen that the learned court below has further reason, on the other hand, that the election held on so and so, by which appellant was re-elected to chairman, CWC shall be considered illegal for violating the provision of Article 38. as appellant had no power to appoint any returning officer to, now this is the finding, my lord. Now your lordship has seen in both the courts below, my lord, they are considering the case of the defendant, whereas it is to be seen first. My lord, in a civil case, the plaintiff has to prove their case. Now, your lordship kindly see what is their pleading. Your lordship may turn to page 79. Their pleading, your lordship will find. First, your lordship may see the cause title, what they want,
Page
at page 74.
74.
Yes. A suit under section 9 of the Code of Civil Procedure, read with section so and so, for a decree declaring the title in favor of the plaintiff and or, this is the subsequent one, and or a decree declaring the election result of defendants dated 12/11/2023. Now, if you want a declaration that you are the president and secretary, the first duty cast on the plaintiff, he has to stand on his own legs. He has to show that the election which held on 14/10/2022, that was validly made. Now, my lord, I will take your, and then your lordship kindly see the prayer. I will take to the body of the petition later on. Now, your lordship kindly see what is the prayer. At page 90,
90.
my lord.
90.
90. The plaintiff claims for declaring the plaintiff right over the title of People's Party of Arunachal. This is his first prayer. As a plaintiff, he want to say that he has to be declared that he is the rightful person who will lead the People's Party of Arunachal. Now, that part of the thing, my lord, he did not plead in his plaint. No question of evidence comes when there is no pleading. Now, both the courts did not go into that. Now, as your lordship knows, there are so many decisions I will place before your lordships. Plaintiff has to stand on his own legs. If, my lord, so far defendant's case is concerned, if there is some lacuna, that should not be gone into. Now, here, everything has gone in a reverse angle. Now, both the courts tried to find out the case, the prima facie case of the defendant, and they did not gone into anything in regard to the plaintiff's title. And your lordship has seen there is no finding whether the election held on 14/10/2022 is a valid one. And even while they are claiming in their, in the plaint, that by virtue of a resolution, the amendment took place, and by virtue of that amendment, the chairman, the post of the chairman has been deleted. Now, I will take your lordships to the constitution of the People's Party. I'll give that one. My copy. My lord, your lordship may come to page 257 in the constitution of the People's Party of Arunachal. ये मेरा है ना? My lord, I will take your lordships to page 265, the relevant provision. ये page नहीं किया ना? Page 265, my lord, article 13, my lord. As your lordship got that.
Yes.
Article 13 speaks, the PPA Central Working Committee is the highest decision-making body of the People's Party of Arunachal. Number one, the PPA Central Working Committee shall consist of the chairman of the PPA State Council, the President, Secretary General, General Secretaries, so and so, so and so. Then, my lord, I will take your lordships. The most important part is the clause 5. The chairman CWC PPA shall be a probing authority of all important decisions of the party. 6. CWC shall be responsible for convening the People's Assembly. 7. The CWC PPA shall be the final authority in all matters regarding the interpretation, application of the provision of the Constitution. Now 8. The decision of CWC PPA shall be final and binding of all members or units. Now, this is the first thing why I am taking your lordship. Now, the chairman is the person who will take all the important decisions. Now, so for election held on 14/10/2022, even there is no whisper in their plaint that there was an approval and the amendment so far this 29 Melod, the post of the chairman has been deleted. Even that one also they did not plead. In regard to the amendment, if you want to do, there must be People's Assembly. Then read with my lord, there must be a notice of one man. There your lordship will find in clause 29A, my lord, which your lordship will find at page 268. Article 29. The party constitution shall be amended only by the People's Assembly.
Page
Page 268, my lord.
66.
268. Article 29.
Hmm.
29 in the top, my lord, in the left-hand
Yes.
side. The party constitution shall be amended only by the People's Assembly. The notice or proposal for amending the constitution shall be given 1 month before the said assembly. Now, to this extent, there is no averment in the print. My lord, these are the very vital thing. If you want to amend, it should be in the People's Assembly, and there too you will have to give a notice before the People's Assembly 1 month before you will have to serve a notice. Now, all these things are done away. They are saying that the amendment was carried on by virtue of a resolution. Now, the court relied on that, said, all right, there may be some, and the court has said, there is maybe some procedural lapses. My lord, when you are going to give an interim ex parte injunction, there must be, because it's after all, it's an equitable relief. When you go to give equitable relief, you must see that whether the other side has come with the clean hands. There must be reasoning to give. Now, all these things has not been discussed at all. What is the plaintiff's case? Nothing. Even plaintiff did not ever that in regard to 29, there must be notice to be given before the People's Assembly. They are saying that a resolution was taken up, and after taking resolution, it was, my lord, abolished. Now, your lordship will find even they have stated themselves on the date when the election was held on 14/10/2022 by the plaintiffs. Now, they are saying that CWC, this is my client, he was there. Now, if he was there, then there must be some sort of approval from him. It is admitted fact, my lord, both the sides. Now, there no such approval was ever taken. And only by saying that on such and such date, chairman post has been deleted. So therefore, we are the president and secretary. There is no chairman, and chairman has no role to play. Now, these are the very shabby way, my lord, both the trial court as well as the appellate court has conducted. Now, I will take your lordships to another clause 36, page 269. This is also very important. 269, my lord. Your lordship will find in the left-hand side, Article 36, Functions of People's Assembly. Functions and powers of the People's Assembly are as follows: to discuss, act on the political and organizational report of the state executive. Now, B is important. To discuss and change means amend, the party programs and constitution. To determine the party line on current situation. To elect the state executive by secret ballot. Now, your lordship will find from their averment in the plea that the election which took place on 14/10/2022, they never say that the election took place. Now, there was a discussion whether the People's Assembly was there. Even there should have been some averment. That averment also not there. Now, in such a situation, if it is given to try this particular suit, there is unnecessary wastage of court's time. Now, forget about, my lord, giving the interim injunction, how the interim injunction has been given. we have seen my lord, I haven't seen in my lifetime that the court is going to, my lord, consider the case of the defendant in order to give ad interim injunction. Ad interim injunction is a very serious matter. A very strong prima facie case will have to be there. And the person who comes before the court, he should not tell lies. Everything should be very clear because it's an equitable relief, because on the averment made by you on the plane, the court is going to pass some order. So, my lord, because at the interim stage, my lord, there is no question of reducing evidence. Just on the basis of paper submitted, the court will believe that whatever you stated.
According to you, the trial court has, the court below has given the ad interim order on the basis of the case of the defendant.
Yes, exactly.
Considering the case of the defendant.
Exactly on the basis of the case of the defendant. And case of the defendant is what, my lord, I'll explain that also. Lord, they are saying that the election which took place on 12/11/2023, that is bad in the sense because the returning officer was appointed not by the president. Now, in these given circumstances, my lord, your lordship will find the president, my lord, he never cooperated after the expiry of the election on 2021. He never cooperated because he has to go for holding election and all that. Now, under that circumstances, my lord, the chairman called for the People's Assembly, and the People's Assembly decided that so-and-so is the returning officer.
Who is that power? Is the chairman or the president?
Chairman, my lord, so far,
You are the chairman.
appointment, I am the chairman. So far, the appointment of returning officer, in usual circumstances, my lord, is the president will appoint the returning officer. But in the instant case, it's a peculiar fact situation of the case. The president has been doing anti-party activities. He is not going for holding election. Under that circumstances, because the election commission won after the expiry of the period, obviously, my lord, election commission has asked who are the party members. So under that circumstances, election was held, and the finding of both the court below, your lordship will see that.
No, in such a situation, what is your constitution provides? Suppose president acted in the anti-party, involved in anti-party
Right.
activities. Then in such situation, who is the power?
My lord,
Is the chairman been given a power?
the People's Assembly will go for the meeting.
We'll go for that. We'll call for that.
And that, my lord, here your lordship will find the president, since he is doing anti-party activities, he did not go for election. And obviously, he will not come and say that, okay, so-and-so may be appointed as returning officer. This is the peculiar circumstances of the case. And my lord, even my lord, there is some lacuna. I'll assuming for the purpose of this argument of the case, I'll assume that there is some lacuna. Can the court go into that? The court will have to decide what is the plaintiff's case, whether they could prima facie satisfy the court to get an ad interim injunction. If that part they cannot satisfy, my lord, interim injunction cannot be given. And the appellate forum decided in the similar circumstances, he never applied his mind. My lord, we have time and again, we have tried to convince that, well, there is no prima facie case under these circumstances. Because if your lordship see, the amendment was not done at all, and the court below has accepted that as if amendment was done by virtue of this resolution taken. Now, your lordship is well aware.
So
if
this
in
is not the impugn order is not an appellable order.
no, impugn order is not an appellable order because the disposal of that will not give rise to a decree. Now, when disposal of the appellate order, it will not give rise to pass a decree. Had it been a decree, my lord, there is a question of appeal comes. So therefore, we filed this under Article 227 of the Constitution. To that part, my lord, there is no confusion, my lord. We have seen that legal position. Now, because of all these anomalies, my lord, I will take your lordship once again to the impugn judgment. And
It's okay. Today, I think we will not be able to, because we'll have to examine. We'll fix this next week and
No,
we'll
the-
hear you on interim.
my lord, what
We'll
will
issue
happen?
notice.
The case will become infractuous because
No,
uh,
can be.
no, in the sense, my lord, my party will not be able to file nomination. Today is the last date. Secondly, my lord, even, my lord, if
In
they do
any
not
case,
have,
it's 11 o'clock.
if the respondent do not have any right, in that case, should
No,
they
I,
go for?
because that has to, it needs an longer hearing.
No, that's
It's to
true, but,
examine all.
but this is the only issue involves me. I will take your lordship certain decision of the appeals court. The legal position have been made very
We'll
clear.
hear it next week. We'll issue notice at best.
No, that's all right, my lord, but
Today,
ultimately the,
interim order is not possible.
the
Would like to
flap-
examine it. Because you are saying that the court below has passed an order, forget about the appellate, this order, impugn order. The basis of the case of the defendant or the lacuna of the case of the defendant in the case of the defendant, right?
yes.
Now, suppose the president was doing something. That's why I just pointed out. President, he being a president, holding the post of president, if he was doing involved in some activity, whatever is not in accordance with the constitution of the party, what is the article provides? Then in such situation, what is the role of the chairman and what is the role of the people's that assembly, something like that? What is the procedure?
My lord, your lordship's questions is a very important one, but not for the purpose of this case.
Yes.
So here is a case, plaintiff will have to establish their case, my lord. What is their prima facie case? Your lordship's question, even I thought it that way, but then so far this case, we are not required to go into that because we are to appreciate whether the plaintiff could establish their case. Because if you establish your prima facie case, only in that circumstances an interim order can be given because ex parte order was given.
No, that's the reason. Had it been a case of that has been considered by the court below.
No,
Wrongly,
that
right,
wrongly.
accordingly.
Lord, your lordship has seen how it is it on consideration? What is the satisfaction derived? On what basis the interim injunction was
That
given?
will examine. That will examine.
Lord, I'll just take your lordship's a few decisions, my lord, if your lordship.
It's okay. It's okay. We'll issue notice. You keep it. We'll hear you on the
Well,
next week.
Next week, my lord, I don't think the importance of this case will remain. Because,
Okay.
my lord, my only question is whether under these circumstances, the
What sort of interim order you want?
interim order means this order is required to be stayed because a person who do not have any right.
In that case, it will be amounting to, I mean, giving you all a full relief in this present.
Now, supposing, my
If
lord,
you stay that order, an interim and appellate court order, then
in that case, if I can satisfy your lordships, if your lordship is
that is the
persuaded to
reason.
some
What
extent.
you want, that's why I'm asking, what sort of interim relief you want today from this
That
court?
interim relief in the sense
If we
of,
stay all this thing, but aren't there?
no, but then
That will be amount to giving you without hearing them.
no, she is there. They what to have engaged someone because this case have got some sensational part also.
No, I'm not concerned that they have filed a caveat and then they are not appearing. We're not concerned. But
Your
this court's
lordships,
concern is,
yes.
suppose if I give you a relief today, it's amount to giving you entire relief.
The question is, if the law stipulates,
Since we are dealing with the legality, same mistake we cannot commit again. Maybe you may be correct.
My lord, I
The
understand.
court has not been.
I understand your lordship's anxiety, but then at the same time, if the court passes an order which deholds the legal position, should it continue for a moment also, my lord? That is the only question.
No, that to come to that conclusion, we need to examine.
My lord,
We need to examine. We need to hear.
my lord, if your lordship look at their plaint, because plaint is the main, when granting ad interim ex parte injunction, the court will look into the plaint only. Now the plaint, there is no averment at all. And the election, how they made on 1410 is a namesake only. They just made some paper. Now there should have been, in order to persuade the court below, they could have made some averment in the plaint.
I'm not sure, but then the same thing which you have been allowed the president to go on after that election in 2022, right?
Yes.
Just because he was involved in some anti-party activities, he just conducted an election. You have never questioned about, I think,
No, that
apart from this legality of the civil case, I think common sense says
the suit is pending, my lord, against
suit is
him.
pending.
My lord, my anxiety
I'll
is
just
that
give you, in that case, I'm not convinced. But then I just don't want to reject the interim prayer. Because according to this court, I mean, prima facie, if we pass the interim order today, this will amount to run to a full relief.
the only thing, my lord,
Nothing remains.
they filed caveat.
That
I
is
was,
that is one
we're
issue.
having an
That is
understanding.
another issue, sir. That is another issue.
It's not that your lordship is going to pass an ex parte order because they are represented by a counsel. And the counsel, if they volunteer not to appear and argue,
But then, if, even after hearing them, this court has hesitation. I have a hesitation, frankly, that this relief, if I hear them also, we'll issue notice or we'll fix the matter next week. We can hear it. Cannot do anything. Interim prayer, I think today it's not possible, at least.
my lord,
And this impure order was on 21 March. Today is 27.
now we filed an appeal and those procedure.
No, 21 March. This
Yes.
impure order is 7 days back.
Now in between there
If
is
there is the urgency, could have decided the matter. Because the nature of the interim prayer you have sought, according to this court, cannot be at this stage, at least without hearing them.
my lord, I do not know whether they did not like to appear today.
What do you say? We should issue notice.
Okay.
That's all.
My lord, can I make a request whether status quo may be maintained?
No. Status quo, what is status quo? Sir, you are well aware. It's in basically though revision petition arises out of the, I mean, ad interim order.
But the question of law
That
is
is
very,
the question, yes.
but the question of law is very strong, my lord. Because even after 1 week also, your lordship will be persuaded to even my lord, in my opinion, the suit.
No,
which has been
even
filed-
after 1 week, we can hear the entire matter. It's a revision petition, it's a question of law only.
The question of law only.
So
And the
that's-
the brief appears to be hefty, but then the
Yeah,
question
yes,
of law
yes.
is very simple.
Only issue is, if I correctly understood, there's nothing, according to you, there's nothing in the plain, no pleadings.
Yes.
But then on the basis of the we'll say defect or the lacuna of the case of the defendant, this interim order, I mean, ad interim order has been
Yes,
passed. That is your case only.
Because
That
the
we need to look into the plain and all those things.
because the court below, my lord, did not derive any satisfaction to pass such order.
Mhm.
Otherwise, my lord, there would have been some reflection.
Mhm.
Now, the reflection your lordship has seen, his finding is that defendant has some procedure, they have accepted. There is some procedural defect.
Yes.
Now, when we are accepting that, how can you pass interim injunction? Now, therefore, my lord, what I felt is a very strong prima facie case we have. Rather, plaintiff could not prove anything. And even the constitution of my lord, the organization, as your lordship has seen, very, very clear. And in that, so crystal clear that they are saying the constitution, some part is deleted. How it is deleted? By resolution. My lord, if there is some provision somewhere, you'll have to go by that. You cannot do any other thing. There are so many provisions.
Anyway, we'll issue notice. When do you want? Heard Mr. as the learned senior counsel, assisted by Mr. MST T.Y. Bhutia, learned counsel for the revision petitioner. Are you appearing?
Yes, Lordship. Only for respondent number
notice.
2.
Huh?
Only on respondent number 2, Your Lordship. I filed my Vakalat number.
MS T. Learned counsel.
Complete, bolo.
appears on behalf of respondent number 2 by filing her power today. By filing this application under Article 227 of the Constitution of India, the petitioners assails the judgment in order dated 21/3/2024, passed in title appeal number 01 of 2024. And also the order by the Civil Judge Senior Division,
Yes.
Civil Judge Senior, London Civil Judge Senior Division, UP, and page 1, this 1, 2, 3, 4, 2. And the order dated 04/03/2024, passed by the Civil Judge within bracket Junior Division, UP. In Miss within brackets MISC, page 2, this order is there, page 2. Issue notice returnable by 3 weeks.
My Lord, can it be fixed on 8th of April?
8th
of April.
returnable by 08/04/2024. Should I consider your prayer and pass an appropriate order?
Your Lordship.
I'm not inclined to grant any interim.
No, in that case, I
I
don't
would say
think,
otherwise I'll be rejecting it.
no, I don't think it is necessary then.
Yeah.
The entire case may be hard.
Okay.
Because
Lordship,
any sort of, my Lord, observation that may affect.
The petitioners to take steps for service of notice upon respondent number 1, except 2, 1, 3, 3, 2, 23, except 2, within 2 days.
We were waiting for 2 only.
Have you received the copy?
Yes, Your Lord.
Okay. No extra copy? Is
Not
required?
necessary.
Not necessary. List the matter on 8 so and so so and so. On
Much
that
of
they will consider
Well,
endeavor.
yes.
Endeavor shall be met to dispose of the matter. You don't have to file any objection or reply. I mean,
No, Your Lordship,
David.
since it's a revision, Your Lordship, this
Question
I will
no.
rely on this.
sorry, sir.
All the papers are on record.
Sorry, sir. Thank you.
It's all right, you know, it's a part of the game.
MS so and so learned counsel for the petitioner. This is the application under section 482. Will issue notice. That's all.
Actually, Your Lordship, same case was already quashed
Huh?
by this honorable court.
Yes.
Same case was already quashed by this honorable court.
Let us see. We'll just call for the thing. All
As
right.
per-
Where it is?
As per order that
Page number 91.
29,
Page number
26, 9, 2023.
Same case.
Yes.
Yes, page
Set
91.
aside.
Set
It has been
aside and
quashed.
twice, yes.
Then what remains?
Why, I don't know why it.
What remains in that case?
Your Honor, my lord, this person, they were actually co-accused were 5 person. So they have already settled the matter outside the court, but
Yes.
this case is non-compoundable. So that's why I have come to the High Court for main quashing of the FIR, because among the 5, only Sunil Lakotia, whom I have already quashed before, application I have filed before the this honorable court, and it was quashed because to that person only the arrest warrant and someone was coming, and for others it was not coming.
No,
Now,
he is saying that if the proceedings and
Yes.
FIR, everything,
Yes.
it's already quashed.
Yes.
What remains there?
No, only for one person, only for Sunil Lokatia.
Is it
Only,
say-
yes, only Sunil
Where- where
Lokatia,
did-
he
where
came,
did they see the order? Is it only in respect of?
yes, Sunil, only one
Petitioner in
person,
that
yes.
case.
And now another person, when the arrest warrant came for another person, that is of the Ritesh Lokatia, now he is coming before the court again for quashing, because they all thought that this FIR has been already quashed up, because they have settled the matter outside the court, and even in the charge sheet of the
Yes,
IO,
come
it
to
was
page
given.
99, page 99. Page 99.
Yes.
Para 9.
Very nice. In week of the going discussion, the petition is allowed and the proceeding of GR case number 78/2009 with under section.
So and so here the
IPC.
question set aside.
Yes,
Proceedings of
set
GRK, if it is set aside, it goes, there's nothing.
Okay, but my lord,
But
during-
MS so and so learned counsel for the petitioner who phrased for withdrawal of the criminal petition.
Yes.
In view of the fact that this court has already quashed the GR case number so and so
But,
in a
but your
other
honor,
proceedings by the order that it
my lord,
Huh?
my lord may please come to the page number 89.
It's
Annexure P6. Here, same case, there, the arrest warrant has come and we have moved out the appearance in page number 89.
(26:9). What is this? 27 page 89.
Yes, 89. Bail level arrest warrant was issued against this Ritesh Kumar Lakhotia. That's why we have moved out the bail application and given his appearance before the honorable court. And we have already given.
Have you informed?
Yes, and
Yes.
even the CTC copy which I have took out from this one in the charge sheet.
But you just said only that the matter has been settled. You didn't
Yes.
say that this proceedings has been settled and quashed.
Yes, I
Page
have seen
89.
that during the this one hearing in the honorable high court.
It was not within your knowledge.
No. During the this one hearing, honorable judge herself has stated that okay, I will quash against only Sunil Lokatia and rest of them I will not quash. I said okay, that also I have accepted. Because for others, someone and arrest warrant was not going on. Only Lakotia, Sunil Lakotia, he was getting the harassment. That's why I have filed for him only at that moment. That's why it was quashed for him only, and for others it was not. Thereby, again, the arrest warrant went for Ritesh Kumar, this one, another accused person. And he too was in the impression that this was already settled outside the court. And so he was living freely. But when the arrest warrant came, then only he realized that case is still alive. So he came and contacted with me, and with that I have filed before the Honorable JMFC court, informing that I have quashed only for one
We'll
person.
take up tomorrow. You read, think about it. All right.
Okay.
Reason being, para 9.
Okay.
It's since the entire case doesn't say in respect of Lakhotia.
Okay.
It says GR case so and so. The proceeding of GR case is hereby quashed and set aside. It doesn't say anything. Have you read the entire?
Yes,
order?
yeah, that I have gone through, but
There might be an interaction between at the time of
but,
hearing,
but,
order
but
doesn't
this
say.
bail level arrest warrant, this one, it shows that case is still alive against others. Only Sunil Lokatia.
No, page 89. You have never told that this proceedings GR case has already been quashed by the High Court. You have only said that the parties have settled the matter.
Mhm.
I understand this criminal petition 138 of 2022. Yes, same section, same GR case 78 2009. What do you say?
Yes,
According to you, once the entire criminal proceeding has been quashed,
because it was quashed on the basis of the
But
same,
then
same agreement.
after the quashing, there is a non-bailable bailable warrant against the petitioner. How is possible?
Uh,
Same case.
Yes, but at that time only Sunil Lakotia and the petitioner's wife, that one widow, only both of them.
Page 99, para 9, read it. Is it talks about the Sunil Lakotia and the wife only? It says the criminal proceeding in GR case so and so, 78 of 2009 is quashed. I'm not blaming you, but the court, why available warrant against? Once the proceedings, entire proceeding is quashed. Nowhere it says it's in respect of the petitioner in those criminal petition, right?
Yes,
Doesn't say anything about that.
yes.
So,
So confusion is regarding the bail-level arrest warrant issued by the
that's wrong.
JMFC.
It would not have been.
Yes.
It ought not to have been. There's no question. When the proceedings quashed, where's the question? GR case 78, right?
Yes,
GR case 78
yes,
of
yes,
2009.
yes. 2009.
Yeah.
But
Order
arrest wa-
doesn't speak quashing, that the order of this court doesn't say that it is in respect of those petitioners.
Mm.
It's entire proceeding. Gone. Finish.
Mm.
How many accused?
5 of them.
So in earlier proceedings, 2 of you have come.
Yes, Sunil Lakotia and the petitioner, that complainant's wife, widow, she came. And during that time, PP, she stressed
let us
that
do
only
one
one person
Let
has
us- let
come
us
and
do-
others
Let
have
us
not
do
come.
one thing.
Yeah.
If you are still not satisfied,
Yes.
we'll fix it tomorrow or next week.
Next week.
You think about it,
Mhm.
read it again,
Mhm.
find
No.
it out, right?
For me,
And,
there is no.
we'll ask the learned additional
yes.
PP to find out
Yes.
whether the case is still pending or
Yes.
is it a different case.
Yes. Mhm.
GR case 78 of 2009, right?
Yes.
Same section, same GR
Yes.
case.
Yes.
Huh?
Yes. So let the PP decide. I have no objection if it is quashed.
No,
For me,
no.
nothing.
In fact, PP will not decide. You have to decide.
Because arrest warrant has
No,
come
no.
from the.
You yourself have appeared in that proceedings, criminal
Yes.
proceeding, criminal petition.
Yes, yes, in JMFC court, yes.
No, no. Here also.
Yes, yes, I have watched, and during that time,
Then
PP,
have you read the order?
no, no, I have read, but during the hearing, even the PP and the
No,
judge.
hearing whatever may be there, but then it has to be, the order has to be seen.
Yes. Order I have seen, it has caused the FIR. But bail-level arrest warrant has given to a co-accused person, that is, which is Lakotia, that's why.
And you have not said, you have not placed those orders, order
No,
of
no,
this court.
it is up. It's already here in, this one. Page 27, My lord, may
Why,
please,
why you are,
peruse
why you
page-
are, why you are holding the?
No, actually, this one is not clear. That's why I'm holding. This is the PP copy. That's why I'm saying, procedure, this one against the Sunil Lokate, it has been written here quas. This is the latest, that one CTC copy I have taken out from the court.
Page,
This one,
page,
27. Page 27. Page 27.
where it is?
11 para, that is Sunil, name of the accused person, Sunil Lokwatia. Procedure put up.
Then,
The Sunil Lokati here, my lord, can please peruse here. It has been proceed, put up and quashed here. It's written.
where it is? Page 27,
Yes,
annexure P3.
yes.
What does it say? Where it is? What is
Sunil
written?
Lokatia, procedure put up and quashed up here. Sunil Lokatia,
Sunil Lokatya, proceedings quashed.
yes.
What does it mean?
Yes, only for Sunil Lokatia it has been quashed, but for others it is not quashed. That's why
Where is your name?
Sunil Lokatia, my name is.
Huh?
My name is Ritesh. That is in serial page 33. Page 33, Ritesh Kumar Lahotia. This is now. I am the person. Arrest warrant against me has come and
Here, remarks made by handwriting is absconding
it's
in serial number 11.
33.
Something wrong. So according to you, still the proceedings is going
Yes,
on
yes,
against
yes,
you?
yes,
Is it?
yes.
Question was actually done on the outcome of basis of same settlement agreement, where all these accused were.
It's not
First
the issue.
party.
Issue is once the entire proceeding is quashed,
Yes.
how can there be a continuation proceeding against her, against the present petitioner? Unless it is only in respect of those petitioners. It doesn't say anything as per the order of this court while quashing the proceedings. Is it so?
Actually,
It's nowhere mentioned. It is not written in the order of this court saying that this quashing is in respect of the petitioners. Doesn't say anything. Is it so?
No. Order was filed because only with Sunil Lokatia and widow of the.
Where it is? Show us, madam. Where it is? I have not found it. That's why I'm saying. Where it is?
This one, Your Honor, this order here only we can see out.
Which
the
one?
name of this one.
Huh?
Order copy. Only with Sunil Lokatia and others and versus state of AP. Only this one.
On the prayer of MSD, learned counsel for the petitioner, list this matter on when?
Okay, after 1 week.
After,
Next week.
after 1 week. You just make yourself clear. Right? This court is of the view that once the entire proceeding is quashed, there is no question of continuing separate proceedings unless it is shown that it is only quashing is in respect of the particular accused. Because that quashing doesn't say anything except the petitioner, name of the petitioner. Nowhere it is mentioned that it is in respect of Lakhotia or something. Right?
I'll see that.
After 1 week.
Okay, much of.
Like
Lordship, this is a criminal joint petition filed under section 482 of CRCP for quashing and setting aside FIR dated so and so and charge sheet number 14/17 dated so and so corresponding to Kaing PS number 10/17 under section 488, 456 and 506 of Indian Penal Code before learned judicial magistrate first class Pangin on the basis of settlement between the parties.
Yes. Heard Mr. So-and-so, learned counsel. Call for the scan copy.
Skin copy of the LCA.
Learned counsel for the petitioner. This is an application under section 482 of CRPC cover 1970 for quashing of criminal proceedings in JR case number 09 of 2017 under section
448,
448, 450 and 56 and 506 of Indian Penal Code by 1860.
Lordship, in interim, the criminal proceeding,
The call for the scanned copy of the trial court records from the learned court of JMFC, Pangi.
Lordship, in the interim,
MS, TG, learned additional PP appears for the state. Learned additional PP appears for the state. In the interim, the criminal proceedings in GR case number 09 of 2017, pending before the JMFC Pangi shall remain state. List
Lordship,
after
one more prayer.
4 weeks.
My name, in my name, there is spell error.
You file an amendment petition.
Leave your place.
Yes.
Yes, my lord. My lord, this is a application for pre-arrest bail under 438 CRPC, my lord. Actually, here the applicant, my lord, may kindly come to page.
No interim. We'll call for CD. Your second wife,
No, sir, yes, my lord.
second wife.
Yes, and from today, my exam has been scheduled, my
This is 306.
306, my lord.
306.
Yes.
Madam,
Yes, your lordship.
306.
306, your lordship. Your
Let me
lordship,
kindly-
She is the second wife. No interim bail. We'll see.
My lord, exam is from today.
In the event
12:30.
you are arrested, you will be allowed to appear in the exam under the
As it-
police.
Only for the exam, my lord, interim maybe,
Huh?
only for the exam, today and tomorrow.
We'll call for the CD. We'll take it up. When is the exam? Exam
Today,
is over now.
12:30, my lord, and I have
Huh?
annexed the documents, today, 12:30, my lord.
It's over now. The moment I sign it, it will be 1 o'clock.
For tomorrow, it will be, I can appear the exam in free of my mind.
If you miss it today, what's the use of appearing?
No, no, I'm
tomorrow?
appearing today, I'm appearing the exams.
Okay, you'll not be arrested if you are not arrested today. We'll call for the CD. No interest, sorry. All right.
My lord, actually for exams.
You
purpose-
said you are the second wife.
Yes, my lord, but only the apprehension is that, yeah, my lord, may kindly come to page 17 also, my lord.
I'm not saying your own pleading. We have seen it.
Yes, yes,
You have admitted everything.
yes, yes.
Perhaps
For the last 10
you could be the person behind it. Because of you only.
my lord, but
Because of only a person has lost her life.
my lord, that is subject to investigation. I'm ready to cooperate with the
I'm not saying
investigation.
that this is a prime facie by your own showing. How can you allow such type of person to go on bail?
For the,
Because
For
of
the-
you only, someone has lost her life,
yes,
right?
yes. But that is
You are admitting
for the
everything.
purpose of investigation. Well, I'm very
You
much
didn't go
innocent.
there, you didn't do anything, but then your conduct You bring, because you are the second wife, because of only she lost her life.
Yes, my lord.
Very unfortunate.
But I'm very much innocent, my lord, here. Actually, I'm ready to cooperate with the investigation and I'll not abscond since
You didn't wish, but then your conduct, because of your action only, one has to lose her life. Anyway, heard Mr. So-and-so, learned counsel for the petition. The applicant. This is an application under section 430 of CRPC. Grant of privilege of pre-arrest bail to the applicant in connection with Nizuli PS case number 21 of 2024. And section 306 of Indian Penal Code 1860. Call for the case diary.
On 2nd of April, Your Lordship.
Call for the case diary.
First, my lord, in that
Huh?
case, 1st of April.
What do you say?
On 2nd April, Your
Interim, what do you say?
Only for the
Only
exams.
on the exams, Your Lordship, I don't have objection in exams. Otherwise, though, the section is of serious nature, Your Lordship. They have themselves admitted to the fact that they were second wife. Otherwise,
Huh?
they have themselves admitted to the fact that they were second wife and the first wife had an issue with that fact, Your Lordship. On exam, only on the ground of exam, Your Lordship, I don't have
I
any
said
objection.
no issue.
Hmm?
Honestly, I approached this honorable court saying that I had no issue with the.
Then
first
in
wife.
that case, you'll appear day after tomorrow.
Yes, my lord. I'll appear
Yes.
All right.
after exam.
Pending production of case diary. Come on. In the interim, the applicant in the interim, in the event of arrest, the applicant shall be released on bail on furnishing a bail bond of rupees 20,000 with one share to be like to the satisfaction of arresting authority. Listen. On the subject to the following conditions. The applicant shall appear before the investigating officer on 29 29/03/2024. Then you just keep two other conditions, right? The interim bail is this order, the interim order is granted only considering that the applicant is appearing for her what exam?
B.Ed exam.
B.Ed
madam,
exam
please.
tomorrow on 28/03/2020.
Lordship may call the CD on 1st of April in that case.
Matter on 01/04/20.
Deeply
Deeply-
obliged.
May it please the Lord.
Yes.
My lord, in this writ petition, I am challenging the termination order of the contract, my lord, which is at page number 510.
510.
10. Now, my lord, here in this writ petition, my lord, what I am urging before the law.
510.
510.
Let's see where it is. It's not a subject matter of arbitration.
My lord, arbitration will come, my lord, if I have a monetary claim. If I have a monetary claim, what I am seeking in this writ petition is that, my lord, this termination should go and I may be allowed to continue with the work.
That cannot be.
Now, my lord, because, my lord, continuation of the work is both in public interest as well as, my lord, in the interest of the project.
No, it's okay. But then since you have been, you are asking for another 12 months. It was supposed to be completed by when?
It was supposed, now my lord will see, it was supposed to be completed by June.
March.
June.
Extended to June.
Extended to June. They terminated in the month of February during currency of the contract period.
It's okay. There may be something. We'll issue notice. Sir,
My lord, I am at this stage, your lordship may issue notice, my lord. I am not asking that something has to be stayed.
yes.
Only thing is that, my lord, no coercive action
Yes,
against me.
yes, we'll see. We'll
No
provide-
coercive action may be
We'll
taken.
provide that only. All
Okay.
right.
Okay, no
Heard
coercive action.
Mr. Ambitious, learned counsel for the petitioner.
My lord, caveat may be discharged, my lord, they are on caveat.
Okay.
Caveat may be discharged.
Okay, why caveat? Who you are?
I'm on.
Who are you?
I'm appearing on behalf of M. Kato.
Huh?
Appearing on behalf of M. Kato.
Union of India.
Okay, you file a caveat.
Yes.
Okay. Heard Mr. So caveat, huh? Caveat is still the chair, huh? Ambitious learned counsel for the petitioner. Agreed by the termination.
Yes, termination order, page 510, dated
termination
11th of February 2024.
Dated 11 February.
Yes,
Is it 11?
my lord.
Is it 11 or something?
My lord.
Huh?
It is at page number 510, it is 11th. However, my lord, termination. 12th, it is 12th of February, my lord. 12.
Where do you get it?
My lord, it is in fact while photocopying at 510, it became that 2, it is appearing as 11, but my lord may record my
510,
submission,
huh?
it is 12th.
12
February
2024, by which the contract, huh?
Yes.
Contract for what?
My lord, at
Construction of
my lord, page 510, subject,
Yes.
subject.
construction of 510, huh? Yes, fine. Span still so and so has been terminated. That's all. We'll issue notice.
My lord.
And in the meantime,
No coercive action in terms of the impugned order.
Mr. So and so appears on behalf of all the respondents.
Yes, madam.
Since so and so appears on behalf of all, there's no formal notice. However, extra copies will be furnished to till returnable then. Notice issue returnable by 3 weeks, 4 weeks.
My lord, will fix a date, my lord, because
3
that would
weeks.
at a date.
Next week.
Can be on April 10th, my lord.
April 10.
April 10th, because I want to execute the work, because if it is delayed to a long time, my lord, 10th of April, month.
At least give them some time. 3 weeks. Huh?
Then my lord,
Till
18th of
returnable
April,
that no coercive action shall be
taken in
by-
terms of the
taken in
termination
terms of
order
the
dated.
termination order dated so and so, so and so. Huh? 12 super. That's it.
I am deeply obliged.
Much obliged.
May I please your lordship?
Issue
Please-
notice.
Notice, okay, all right. My lordship, only one request I have, my lordship. Some urgency there, my lordship, so a short date may be given, my lordship.
Huh?
A short date may be given, my lordship, for returnable date. My lordship, please-
Normal that will give.
okay, 2 weeks, my lordship.
Heard Mr. So and so learned counsel for the petitioner. What is your prayer? Are you challenging the
Yes,
suspension order?
yes, your lordship. We are
Ah.
challenging suspension order, your lordship. We are challenging the suspension order. Your lordship will find the suspension order on page number 18, your lordship, annexure 1.
Why you are challenging it?
Your lordship, because your lordship, according to the law says that according
By
to the
filing this application, the petitioner has challenged it. The petitioner is aggrieved by the order of suspension dated 01/12 December 2022, whereby the petitioner was put under suspension after he was arrested in connection with SIC within bracket BIG bracket clause PS case number 12 of 2022 under section 120 bracket capital B bracket clause 406, 409, 420 IPC read with section 7, 8, 13 within bracket 2 of PC Act 1988. And the further continuation of suspension without there being any review as per the, as required under the law. Mr. Issue notice returnable by 3 weeks. Mr. T. Tagumlan, Standing Counsel for Education Department, enters appearance on behalf of all the respondents.
Yes, my lord.
Since Mr. T. Tagum accepts notice on behalf of all the respondents, no formal notice needed. However, accept notice be furnished to the legal counsel during the course of the day. This after 3 weeks.
Deeply obliged.
May I, my lord?
Yes,
My lord, I would like to, I want
you
to,
would like to withdraw,
yes,
withdraw
my-
this writ petition.
No, withdraw our Bakalat Nama
Why?
because, yeah, petitioner is not cooperating with us.
You have to, in that case, you have to issue a notice, not
I have-
withdraw.
I have already this no objection certificate which is received by petitioner.
This is by whom?
For petitioner,
Hmm?
petitioner.
Client wants to appoint some other lawyer.
Yes,
Huh?
yes. We have no objection.
No, no, you may not have any objection, but then. Okay. I heard Ms. So-and-so learned counsel for the petitioner who, by placing the no objection certificate issued by her senior, who is the leading counsel in this matter, pressed that they may be allowed to withdraw from the case. Which has been accepted by the petitioner. Please do. In view of the no objection certificate issued by Sri T. Tony Learned Counsel for the petitioner, the learned counsels appearing for the petitioners are hereby allowed to withdraw from the case as the same is being accepted by the petitioner in the said NOC. Mr. MS R. Basir, Learned State Council, present. This after 3 weeks. The NOC be kept on record.
Much objection.
A copy of the NOC. Huh?
May it please, your lordship.
Yes.
Lordship, on the last occasion has written a CD and had called for an updated CD, your lordship. The petitioners were directed to appear before the IO, your lordship. As per my information, your lordship, they have not appeared, your lordship.
I have directed my client to appear before the IO also. And as for the statement, same, he said he went there, but IO was absent. Same, he used to say.
We'll reject your bail application.
Your Honor, last,
He did
Your
not-
Lordship, last opportunity may be given.
Huh?
Last only
How
for
can you
short
play
date,
like
Your
this?
Lordship.
You cannot be allowed to do like this.
Your Lordship, this is not the first time. Earlier also he was appear before the Your Lordship. As per the order, Your Lordship.
You went there and your appearance is not shown there. That is
That's
what you
why,
are trying
Lordship.
to say.
Your Lordship, as per the order dated 16
When did you appear?
Your
According
Lordship,
to you?
Your Lordship, I could not ask the date actually, Your Lordship.
Huh?
Only by telephonically, only he informed me that he went to the PS and I was not there.
You listing it next week. You take a call. If he's not cooperating you give up
Okay, Your
this
Lordship.
case.
Okay.
What was this last order?
Twenty-one-3.
Where is the? Do you have the updated case diary?
Your Lordship, no, Your Lordship, only his statement itself is, the investigation is pending only for taking up of his statement, Your Lordship.
So according to you, he did
He
not
did not
appear.
appear. Your Lordship will even see that even my CD on the last occasion, Your Lordship, even this honorable court on 2 occasions has specifically mentioned 2-3 dates when he has to appear, Your Lordship. 5 and 6 of my objection of this in the CD, Your Lordship.
Hmm?
Your Lordship.
Even on those dates, Your Lordship, only a submission was made before this honorable court that
Your Lordship, as per the order 16/2/24, I was appear before the IO, and I think I have submitted the original copy of that one also, which was received by Your Lordship, SIMK Doimuk PS, Your Lordship.
We'll give you another chance to appear tomorrow.
Lordship.
Tomorrow. You appear tomorrow. Is he a government servant? No. Is he a government servant?
No idea,
No.
Your Lordship.
No idea.
Yes.
Come on. what
About
is
his
this?
profession.
Huh?
About his profession, no idea, Your Lordship.
You must know.
no, he's not
You
a
must know
government
your
employee.
client.
Your Lordship,
You
two
must
dates
know,
may be
know
given.
the client's antecedents, everything, profession. You must know that.
Actually, Your Lordship, this matter has been taken by my senior Titaba only, Your Lordship.
Huh?
So, this matter has been taken by my senior Titaba only, that's why, Your Lordship.
Heard MS so and so, learned consent for the petition. And also the MSTG in it, learned additional PP. List this matter on 02/04/2024.
Lordship, if I may pray,
petitioner-
if the matter is fixed on 4th, Your Lordship.
04/04/2024. In the meantime, the applicant is directed to appear before the IO on when?
On 2nd of
02/04/2024. Failing which appropriate order shall be passed on the next date fixed.
deeply.
My lord, may I please?
Yes.
My lord, this is a bail application, regular bail application.
Yes.
In connection with
What is the stage of trial?
my lord, the
Charges has been
consideration of charges will be tomorrow.
Tomorrow.
Yes, and I'm already in custody for 100 days, including today. And the date of filing 70
Doesn't
days.
matter.
Yes.
POPSO case.
Yes, sir.
We'll take it up next week. Otherwise, I'm rejecting it. You may approach it before the trial court.
Your Honor, I have file a bail application before the district and session judge, but it was rejected, which I have annexed with this petition. And I have
What is the ground of your bail? What is the ground?
ground of bail. And I have also approached the juvenile court also, because there is a disputes in age.
Dispute in the age?
Yes.
Of the age, regarding age?
Yes, yes.
Ah.
But it was
According
also
to, what is
rejected.
the age of the victim?
17 years
Hmm.
at the time of commission of offense,
Yeah.
alleged offense.
When it
It was also not considered
Hmm?
by the juvenile court.
Hmm.
So today I am here.
No, it's okay. What is your ground for granting, seeking bail?
Your
What is the
Honor,
ground?
now
100 days.
100 days over.
Hmm.
Now I'm in custody for 100 days.
It doesn't
Now
matter.
charges has been filed.
Huh?
There is no chances of flight and evading from trial, absconding, no chance. And I'm ready to provide a reliable security. With the bailer itself is my cousin sister. My sister.
Huh?
Bailer, applicant. Applicant is my
We are
sister.
not concerned about the bailer. Huh?
And my lord, this is allegation is under section 15 of the POCSO Act. If we peruse
This matter on 04
Yes,
2020. We'll consider on that day.
Obla,
yeah. 18, 19,
Yeah, plus Mal.
18.
Yes, Mal. Hello, this is a subsequent bail application filed by the applicant, who is the younger sister of alleged accused person, who has been linguistic.
LCR is, TCR is there.
It's
List next week. LCR is yet to be received. Huh? Reminder for TCR. List on 05, no,
8.
0804 2020. Reminder for.
Item number 28.
Your Lordship, a reminder was given for the CD, Your Lordship. Though reminder was given for the CD, Your Lordship, we have not received the CD.
She's on bail, interim bail.
There is an interim.
But
It is heard MS so learned counsel for the producer. MST in learned additional PP submitted. Case diary.
Case diary.
She is yet to receive the case diary.
Your Lordship, last time
List
there
this
was
matter after on when? 09.
09, Your Lordship.
09
Your Lordship.
04 2024. Interim order first arrest shall continue.
Deeply.
Anything else?
Your Lordship.
Anything else?
Actually, Your Lordship, we couldn't execute last time because he was in remote area, so maybe given time to execute it.
It's better keep quiet, otherwise
In
you'll
the
have to
event of
trouble.
arrest.
We'll have to cancel that in that case. You do it, whatever.
Deeply.
All right.
Much of
Sorry for interruption, my lord. Item number may be taken up on 4th of April.
Which one? Item 18?
18.
We said 4th of April. Is it? No. Then in that case, 4th. 040.
All right.
04.
Deeply.
Item number 28.
Yes, madam. What do you want today?
I have been bring back my Lordship file.
Yes. What do you want?
Your Lordship,
It should be listed some other date.
Your Lordship, I already brought back my file.
Okay. You have misplaced your file.
Yes, Lordship.
Huh?
Yes, Lordship.
We are yet to receive the
Scanned copy of LCR.
MS so-and-so learned counsel for the, MS so-and-so learned counsel for the petition. Next para. Office note dated 26/03/2024 reflects that trial court records as called for is yet to be received. Accordingly, list this matter after 2 weeks.
Next week. Oh, yeah.
2 weeks.
2 weeks. Okay, Lordship.
I don't know, 42.
Yes.
My lord.
Just call again. 32. Item 32. Mr. Pangin has taken the time to
Obtain
obtain
instruction.
instruction because his prayer is that there is no
No
promotional
promotional
avenues.
avenues in the Director of Elementary Education.
Yes.
On account of one of the posts being held up and retained in the DSE, Director School Education. That's now secondary education. Now subsequently the post has been created, ma'am. That there are altogether 4 superintendents in the Director of Elementary Education. And
This is something else. His prayer is challenging the promotion of the private respondents. Huh?
my lord, that is the genesis of the case that they are putting is that since the post it was allocated to the DE, Director Elementary Education, it's being retained in DSE. That's why, and against that post, that's
These are the respondents are secondary education.
Yes,
It
ma'am.
has been bifurcated.
Yes, ma'am.
The petitioner is from elementary.
Yes, ma'am.
So there were no post for the elementary education.
My lord, there was my lord.
Only
Now,
one post.
Only one post, my lord.
Now
only
you
one
have
post.
created another 3.
Yes, yes, my lord.
So
Now-
on your own, in the Department of Elementary, it can be considered
Yes, yes, my lord. Now, provided
on
if
its
they
own
qualify.
merit. On its own merit.
Yes,
They are touching the
yes,
post
yes,
where
yes,
the respondents have been already
Yes.
promoted.
Yes, yes. 4 respondent, four.
So what is to be done?
Otherwise, the last occasion also this court has observed that the grievances petition is already seems to have addressed, man, because
But prayer is challenging the promotion order of the from a different different. It's a different. You cannot say that what is called
it is
different directorate.
Yeah, different director. Now, what happened? Although that
Who was appearing this morning for the petitioner? Somebody was appearing.
their morning, there was there.
Mr. Non appears on non appears for petitioners on call. Mr. T. Tagum, learned standing counsel for Education Department.
Yes, ma'am.
Appears for is present. It is noticed that on 13/03/2024, this court, on the perusal of the instruction received by the Understanding Council for Education Department, has observed the grievance raised by the petitioner with regard to the absence of avenues for promotion seems to have been redressed. The learned counsel for the petition has sought for 2 weeks' time to receive instruction. However, represented the petitioner to the lister. Considering that next para, the matter is of 2016, another opportunity is granted to the counsel of the petitioner to obtain instruction. This matter on when? On 08,
my lord.
No, on 09/04/2024.
9.
On which the learned counsel for the petitioner is directed to place the instruction. It is also provided that the matter shall be taken up for disposal on the next date fixed.
Deeply honest.
Yes, madam.
May I please, Lordship?
Yes.
Only on instruction, I am seeking for the adjournment. So kindly matter may be adjourned for today and a short date may be fixed for the supplementary hearing.
What is the matter?
Actually, Your Honor, my name is not there in the wakalatnama.
No
And
matter.
I'm not well acquainted with the case.
Doesn't matter. We'll allow you to argue without wakalat.
My senior has not been instructed me to do that. No?
Who is your senior?
N. Dangen.
Huh?
N. Dangen.
Where she is?
She's out of station.
Over the telephone, you said that this court wants you to appear.
I have informed her, but she said that she had not instructed me for the argument and all. And I'm actually,
Did
my
you-
name,
did-
it's an all case and my name is not in the wakalatnama.
Did you tell her that the court wants you to argue the matter?
I told her, but she
What
said
about her?
she will do the argument
Huh?
because I'm not well aware and acquainted with the cases now.
What is the matter?
Your Lordship, may I-
Are you ready?
No, Your Lordship, actually, Your Lordship.
You too is not ready.
Next, Your Lordship, this case is mainly conducted by the land management. Standing counsel is there, Your Lordship.
What is the
Mr. D.
issue?
Kamduk, he is, Lordship, basically, the petitioner, he is aggrieved by the DPC order by which he was,
First he was promoted and was
first he was
reverted back.
rewarded back to his earlier
Yes,
post.
his promotion on the basis of the amended rule.
Yes, Your
This
Lordship.
court has said
Yes.
that you cannot, the applicable rule would be the unamended one
Yes.
when the post was vacant. That is
Eh.
the challenge.
And also, Your Lordship, he is
On the
challenged.
joint prayer of learned counsel for the petitioner, list this matter on when?
Short date may be fixed.
Huh?
Short date may be fixed.
When do you want?
After 1 week,
After a week. We'll see.
Obliged.
okay, what time is it?